You're watching the legal breakdown. So, Glenn, we've got the news that I think a lot of folks didn't think would ever come. Talk about the trial date for Donald Trump's first criminal prosecution.
Yeah, Brian, it looks like we are finally getting Donald Trump into a defendant chair. He has been playing musical chairs with all of his criminal cases for so long that we've all been waiting for the music to stop. Well, today it stopped, and the first defendant's chair in which he will be seated is up in New York now. This is his trial on 34 felony counts for interfering in the 2016 election. It is technically a falsifying business records case. That's what the 34 counts involve. And of course, he was falsifying business records because he was trying to cover up. He was trying to disguise the true nature of hush money payments he was making to playmates and porn stars to try to bury deeply damaging information from the American voters in advance of the 2016 presidential election. So at its core, this is also an election interference case. Well, today, the presiding judge, Judge Juan Merchan, denied all of Trump's lawyers' motions to dismiss. It was a real throw the spaghetti at the wall and see what might stick motion. And if anybody's interested, they can read Judge Merchan's 30-page ruling setting up and knocking down every sort of borderline frivolous claim that Trump's lawyers made to try to get him out from under this criminal trial. They then tried to continue the case till a date farther down the road, expressly complaining, Judge, this is going to interfere with his campaigning schedule, which is really an absurd argument for a lawyer to make. Judge Merchan would have none of it. And he said, we will start jury selection on March 25th. So it makes some sense, and there's some symmetry, Brian, because these are the earliest crimes he committed across the spectrum of his 4 criminal cases. This is the first indictment that was handed down against Donald Trump, indeed handed down for the first time in our nation's history against a former president of the United States. And now this will be the first criminal case that goes to trial.
Well, is there any stunt that Trump's team can try to pull now to, in a desperate effort to get this delayed? Can he fire his lawyers, for example, and claim that he needs more time to get new representation up to speed?
There are 3 stunts, all of which I predict will fail. The first one, as you mentioned, it's not unusual for a defendant who desperately wants to avoid an upcoming trial date to try to fire his lawyers and then go in and tell the judge, I need to hire a whole new legal team, and they're going to need, 6 months to a year to gear up for trial. I've seen that attempted time and time again in my 30 years as a prosecutor, and here's how that plays out. The judge will inquire the basis for a defendant's attempt to fire his lawyers, understanding and recognizing that it's really all about delay at the end of the day. And then the judge has the discretion to tell the defendant, I'm not permitting you to fire your lawyer, so you will go to trial with the legal team that I have been dealing with, for a year or more now in the run-up to this trial date. That's one stunt that Trump will perhaps try to pull, but it will fail. Another stunt is he'll try to take some bogus appeal of one of Judge Merchan's rulings, for example, one of the rulings to dismiss the indictment. But that should not delay matters because that really is not an appropriate appeal to take before the trial. It will certainly be an appropriate issue for him to raise in his appeal after the trial is over, assuming he's convicted. And once he's sentenced, then he can appeal any and all issues he wants to appeal. The third thing he might try to do, Brian, is file some kind of a motion for relief in federal court, claiming I don't know what. It won't be a persuasive claim, but he may make some half-baked supremacy argument, none of which is really based in reality or based in law or based in the Constitution. But he might hope he can perhaps win some delay if he tries to bring suit of some kind in federal court to put a stop to this prosecution. Those are the 3 stunts that I can think of, and they will all be losing efforts, in my opinion.
Just as a quick aside, on the third one, can he do what he did in the DC prosecution, appeal to the federal court in the same way that he appealed on the immunity claim, and have to wait until the federal court resolves that issue before anything else can move forward in the New York court?
No, because first of all, he appealed the immunity issue. That was from a federal district court, and he appealed it to a federal appeals court. Now, of course, it's perhaps being appealed to the Supreme Court. Um, but the reason he gets to enter those appeals before the trial is because immunity is different. Immunity, if you really have it, means you shouldn't have to be made to stand trial. You
Right.
shouldn't even have to spend one day preparing to stand trial if you actually have immunity. Donald Trump doesn't. But there is no immunity claim in the New York State prosecution. The only claims that Judge Merchan just denied were run-of-the-mill motions to dismiss the charges, but those are not the kind of issues that a defendant can appeal before his trial is over. So I don't think any of Trump's appellate ploys will slow his trial down in New York at this point.
Okay. All right, Glenn, let's get into the to the good stuff here. What's the timeline for a possible conviction given that the March 25th trial date is now confirmed?
So predicting exactly how long a criminal trial will last is a fool's errand. Interestingly, I undertook that fool's errand for 30 years because at the beginning of every trial, the judge would ask me as the prosecutor, Mr. Kirshner, how long do you anticipate this trial will last? I don't think I ever got it right, at least not right on the nose. But, when you look at a case like this, 34 felony charges for falsifying business records, probably lots and lots of documentary evidence, a fair number of witnesses who will have to testify. I would put a trial like this at about 4 weeks, give or take. It could go a little bit more quickly. It could last a little longer than that. But I have to tell you, Brian, I think we might see Donald Trump convicted, found guilty on the charges because the evidence really is overwhelming, as early as perhaps the first part of May.
Okay, which of course, even if we go super conservative and you say June, for example, I mean that's still plenty of time before the election for people to go to the polls knowing that they would be casting their ballot for a convicted felon. To that point, Glenn, what about sentencing for a crime like this? What could Trump be looking at here with the caveat, of course, being that nothing happening here tends to follow the normal laws of physics?
So this is a Class E felony, falsifying business records, categorized as a nonviolent crime. And the punishment for a Class E nonviolent felony under the laws of New York is a maximum of 4 years in prison. Of course, there are 34 charges. Now, that doesn't mean if he's convicted on all 34 counts, he will get 4 years per count. It doesn't mean he will get 1 year per count. Often when you have a course of conduct like this, the sentences might tend to run together. I don't want to turn this into a legal breakdown law school class, but often when a whole series of crimes get charged, the sentencing can kind of collapse, and there can be what we call concurrent sentences handed down by the judge. Concurrent sentences just mean even if you were sentenced to 1 year on each count, many of those 1 year sentences might be run together concurrently, such that you can serve all of them virtually at the same time. I do think Donald Trump is likely looking at a sentence to some period of incarceration. However, let me hasten to add, these crimes are what we call probation eligible. So even if he's convicted on all 34 counts, the judge could, for example, impose a sentence of incarceration, but suspend it and put Donald Trump on probation. And if he successfully completes probation, he would never have to spend a single day in jail or prison or a confinement facility. So I think the sentencing piece is wide open, but given the nature of the crimes, given the number of the crimes, and Brian, given that he was committing these crimes, or at least he was continuing to commit these crimes by writing Michael Cohen reimbursement checks in furtherance of this false scheme, these hush money payments that they were covering up. Donald Trump was writing those checks out of the Oval Office while he was president. So, this is a pretty aggravated falsifying business records case. And at its core, it's an election interference case. So I would expect Donald Trump to be sentenced to at least some period of incarceration.
All right, let's finish off with this. I know that we've spoken about this case relative to the seriousness of the other cases, which is not to downplay the seriousness of this one, but I mean the election interference case in Washington D.C., the classified documents case. These are major cases that that Trump will be contending with soon. Do you think that it's less likely that we would see incarceration for this one, knowing that it would be perceived as like Trump being incarcerated for something less important than those other ones? Do you think the judge would be less inclined to incarcerate him for this one?
Brian, that's a great question that is entirely unanswerable, but let's take a stab at it. Remember, there seemed to be a lot of hesitation before any prosecutor in any jurisdiction would pull the trigger and indict, for the first time in our nation's history, a criminal former president of the United States. Which was the first jurisdiction to do it? It was New York. So let me kind of use that as one data point. I have a feeling Judge Merchan will do the best he can to sort of divorce from the sentencing calculation all of the other cases that are coming up that, yes, are more serious in a number of ways. For instance, in Florida, in the federal prosecution, we're dealing with espionage charges,
Yeah.
literally. We're dealing with obstruction of justice. We're dealing with compromising our national security, pretty deadly serious. Down in DC, we're dealing with a president who lost the presidential election and then tried to criminally and unconstitutionally, reverse the results, expressly override the will of the American voters. Again, deadly serious stuff. So I think there may be this tendency for a judge to say, boy, he's got some really big potential sentences coming up if he is convicted in those federal cases. But I don't think that would lead Judge Merchan to say, even though I think incarceration is appropriate in New York for the offenses of conviction, assuming he's convicted, I think I'm going to put him on probation because there are bigger sentences coming. I don't think that's the way a judge will think. I don't think that's the way a judge will want to think. But I do think it's hard to completely block out everything else that we know is headed down the track directly for Donald Trump in these other criminal cases. All of that being said, my money is still riding on Judge Merchan, giving the sentence that he believes is appropriate based on the offenses of conviction if he's convicted. And again, my sense as a former career prosecutor is that is a sentence that would include a period of incarceration.
Okay, well, we have the benefit of being able to find out not too long from now. So, of course, with that said, for anybody watching, if you want to follow along with the progress of this case as it moves towards its completion, which we hope will be sometime this summer, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.